Hi, this is Dan Smith of DPS Legal Counsel. Welcome to today's video. Today I'm going to be talking about a topic of importance to businesses that operate as LLCs. Either you're preparing to start an LLC or you have an existing LLC, you need to think long and hard about your operating agreement, which is the fundamental document or contract between the owners of an LLC that sets forth what the rules and regulations for operating the LLC are. And so if you have if there are two of you that are starting an LLC, and I've seen this, if you have two members who are going to start an LLC together, the temptation or the inclination may be that each member will be a 50% owner, 50% member of the LLC. And if you do that, and there's nothing inherently wrong with doing that, there's nothing to prevent you from doing that, but if you do that, you need to make very clear in your operating agreement how you are going to handle future disagreements or disputes or controversies between you and your other member, your partner essentially, if you have a deadlock. In other words, one of you wants to do something, one of you doesn't want to do something. One of you wishes to take a certain action, the other opposes taking that action. What happens when you each are 50-50 owners of the business? If you don't provide for that in your operating agreement, if you don't provide a deadlock provision or how to deal with a deadlock provision, then you have a problem just waiting to happen to your business. If you have a deadlock situation and you don't have any way of resolving the deadlock under the terms of your operating agreement, then it's likely that the dispute is going to end up in a judicial setting, in court, with one of you, either you or your partner, filing something with the court, filing a lawsuit with the court to determine what next step should be, or perhaps even to dissolve the business, dissolve the LLC. Because if you reach an impasse, you reach a deadlock on a particular matter of importance to your company, to your business, and you can't resolve it any other way, a court will have to step in at some point and resolve it for you. That's something you don't want to have happen. You want, on the front end, when you are setting up your business, when you are thinking about your operating agreement, if you have two members and you're each equal members, you need to have a very clear, precise provision in your operating agreement that deals with what you do in the event of a deadlock. Now, there are multiple ways that people have come up with over time to deal with deadlock situations. One common way is to have a provision that essentially says that if there is a deadlock, one of the members, one of the partners can say, I will buy your interest for whatever the offer is that is made in that situation. I'll buy your business, for example, for $100,000 cash. Or if you don't wish to sell it to me for $100,000 cash, you have to buy mine for $100,000 cash. It's essentially, I'll agree to buy it from you, but if you don't want to sell it to me, you have to buy mine. That's a common provision that just basically says, I will offer you a choice. Either you sell it to me for what number I set, or I'll sell it to you at that number. That's a common provision in a deadlock situation. Whether that's something that you would want in your individual, your particular operating agreement, I don't know. But that's one way. Another way is to have a provision for allowing an independent appraisal of the business and a mechanism for one party or the other then to buy or sell based on that appraisal, rather than one of the members coming up with what the purchase price would be. A third might be to have an independent party that you have already selected, either a person or a group of people, a committee, someone that is trusted by both of the owners of the business to make the decision in the event of a deadlock. That would allow for a decision to be made short of going to court. You even may see a provision now and then in an operating agreement that if there's a deadlock and there is good faith efforts to resolve the deadlock and it can't be resolved, that it may be resolved by some arbitrary method such as flipping a coin. If that's a good idea for you, then that's a good idea for you, but I'm not sure that makes a whole lot of sense in most commercial businesses. But it at least addresses the issue that there could be a deadlock. So what I would say is, if you're getting ready to start a business, or you have an existing business, and you have two equal owners, you want to make sure now, before you have a dispute, that you have a provision in your operating agreement that deals with what happens in the event of a deadlock. Because if you don't have that provision in your operating agreement, sooner or later, more likely than not, you're going to have a disagreement with your partner. And when that happens, there could be problems if you don't have a way of dealing with the disagreement. Okay, I hope that helps. If you have any questions or want to get in touch about your particular issue or your particular matter, you can check out my website at dpslegalcounsel.com. Give me a call. I'll be glad to talk to you about your particular issue. And until next time, we will see you then.